Civil asset forfeiture is a strange beast. It comes from Old England. It's what's called common law. And what it was is the idea that someone would be um, poaching deer on the king's property. And when they got caught, they would say that the bow and arrow itself was guilty. And so the case would be the king against the bow and arrow, and the king would get the bow and arrow. Nowadays, it's used here when, let's say, they bust someone who they think is selling drugs and they've got a bunch of cash. So they take the money. And the theory is that once the money was used in an illegal drug transaction, it actually at that moment became the property of the government. And therefore, they can take it from you if they can prove that it was either the proceeds of a drug transaction or the property was intended to facilitate a drug transaction. For example, you have a generator that's running the lights in your warehouse. They could not just bust you for growing the weed in the warehouse, but they could take away the generator and say that that helped facilitate it, or it was bought with drug money, and therefore the government gets to keep it. It's usually done with cash, sometimes with automobiles, though it's a little more difficult, sometimes with property. The key is that most lawyers, most civil lawyers have never touched a civil asset forfeiture case, and most criminal lawyers have done very few of them. And when they have gotten a companion asset forfeiture to the criminal case, they just use it as a bargaining chip and they usually deal it out. You keep the money, give my client something lighter. The truth is that you can fight civil asset forfeiture. It's not easy. You need a lawyer that really knows what they're doing. It's one area where the courts have said that the government must strictly comply with all of the rules. And if they break even a little rule, you can win. For example, what often happens is the police come, they search your house, they find $20,000 cash, and they give you a notice of seizure intent to forfeit. And the cop hands it to you, and that starts it. Well, that's no good because there are cases that say it has to be initiated and served by the district attorney or the attorney general. So if the cop has the form and fills it out and serves it, that's not a valid forfeiture. But most people and even most lawyers do not know that. And there are scores of people who have been served improperly this way that have lost their money. So if you get any of your money seized, your bank account seized, etc., you need someone who has experience in asset forfeiture. They're few and far between. My very first federal case I worked on was an asset forfeiture case where back then they arrested my client in a $65,000 Mercedes. And this is back in 1987 when $65,000 was a lot more than it is today. They took him into custody. There was a warrant out for him, and they found in his wallet a half a gram of cocaine. And based on that half a gram of cocaine, they attempted to forfeit the Mercedes. We were able to protect that, and the laws have gotten better since then, but still, it's a very difficult area of law. You need someone with real experience if you have an asset forfeiture matter. Thanks.